Federal marshals just executed seizure orders on 3 Trump Organization properties across 2 states. At 6:15 a.m. this morning, armed U.S. Marshals arrived at Trump's Westchester golf course, his Wall Street office building, and his Doral resort in Florida, carrying court orders authorizing immediate possession of the properties to satisfy outstanding federal judgments totaling $547 million. And this isn't a temporary hold or a negotiating tactic. These are permanent asset seizures backed by federal court enforcement orders that strip Trump of ownership rights and transfer control to government-appointed receivers who will liquidate the properties to collect on debts Trump has refused to pay for over 14 months. When federal law enforcement shows up at dawn with court orders to seize properties worth hundreds of millions of dollars from a former president, you know the legal system has reached the absolute end of its patience. Hit that subscribe button right now because you won't want to miss any of the videos I release. So what triggered this extraordinary federal enforcement action? Court records filed in the Southern District of New York show that Trump failed to satisfy 3 separate federal judgments entered between November 2024 and December 2025, despite repeated court orders demanding payment or posting of appeal bonds. According to the U.S. Marshals Service, Trump was given a final 30-day deadline on December 20th, 2025, to either pay the outstanding judgments, post adequate bonds, or demonstrate genuine inability to comply. When that deadline passed with no response from Trump or his legal team, federal judges in New York and Florida issued enforcement orders authorizing the Marshals Service to seize sufficient assets to satisfy the debts. This isn't just another legal complication or business setback. Legal experts specializing in federal judgment enforcement are calling this the most significant asset seizure from a former president in American history. And believe me, when federal marshals arrive with moving trucks and padlocks to take physical control of properties that define a person's business empire, something absolutely catastrophic has reached its conclusion. Here's the full picture of what's been unfolding. Tensions between Trump and federal courts have been intensifying since late 2024, fueled by mounting civil judgments, Trump's pattern of defying court orders, and his public statements dismissing federal judicial authority as politically motivated persecution. But everything reached a critical breaking point in mid-December 2025 when federal judges in 3 separate cases coordinated enforcement proceedings after determining that Trump was deliberately evading payment through strategic property transfers and shell company arrangements designed to shield assets from collection. The seizures stem from 3 distinct federal judgments. The first, a $187 million judgment entered in November 2024 by Judge Lewis Kaplan in the Southern District of New York, relates to additional defamation claims brought by E. Jean Carroll after Trump continued making false statements about her despite previous court orders to cease. The second judgment, $216 million, entered in March 2025 by Judge Arthur Engeron in the same district, represents accrued interest and penalties on the original New York civil fraud judgment after Trump failed to post appeal bonds. The third judgment, $144 million, entered in August 2025 by Judge Aileen Cannon in the Southern District of Florida, stems from sanctions and attorney fees assessed against Trump for frivolous litigation brought against former government officials and media organizations. Combined, these judgments total $547 million, and court-appointed monitors determined in November 2025 that Trump had the liquid assets and borrowing capacity to satisfy the debts, but was choosing not to comply. Financial records subpoenaed by the courts showed Trump had moved substantial assets into offshore accounts, transferred property titles to family members and shell companies, and liquidated holdings to purchase exempt assets like expensive artwork and collectibles that are harder for creditors to reach. Federal prosecutors argued that this pattern of conduct demonstrated willful evasion that justified immediate seizure of remaining accessible properties. Smash that like button if this is making sense so far. Here's where it really gets serious. On December 20th, 2025, federal judges from the 3 cases held an unprecedented joint teleconference with Trump's attorneys and issued a final ultimatum. The judges stated clearly that Trump had exhausted every accommodation, that his pattern of asset shifting constituted fraudulent conveyance designed to evade legitimate debt collection, and that unless full payment or adequate bonds were posted within 30 days, they would authorize federal marshals to seize properties sufficient to satisfy the judgments. The conference call transcript, which was filed with the court and became public record in early January, shows Trump's lead attorney arguing that the judgments were under appeal and that seizure before appeals were resolved would cause irreparable harm. Judge Kaplan responded that Trump had been given over a year to post proper appeal bonds, that his failure to do so waived any right to delay enforcement, and that the time for warnings and accommodations had ended. He stated that federal judgments are not suggestions, that courts have both the authority and the obligation to enforce their orders, and that Trump's status as a former president entitled him to no special treatment that would excuse him from legal obligations imposed on every other judgment debtor in America. Here's what multiple sources familiar with the enforcement planning say happened next. On January 3, 2026, the U.S. Marshals Service received formal execution orders from the 3 federal judges authorizing seizure of specific Trump Organization properties identified through asset discovery proceedings. The Marshals Service spent 2 weeks conducting surveillance, reviewing property records, and coordinating with state and local law enforcement to ensure the seizures could be executed safely and efficiently. The target properties were selected based on several criteria. They needed to be unencumbered by senior liens that would complicate title transfer. They needed to have clear market value that could be readily appraised and liquidated. And they needed to be properties where Trump maintained direct ownership through entities he controlled, rather than properties with complex ownership structures involving multiple partners who might challenge the seizures in court. The 3 properties ultimately selected were Trump National Golf Club in Westchester County, New York, a 140-acre facility valued at approximately $180 million based on recent comparable sales. The 40 Wall Street office building in Manhattan, which Trump owns through a ground lease arrangement, with Trump's leasehold interest valued at approximately $220 million. And Trump National Doral Miami Resort in Florida, a 643-acre property with 4 golf courses valued at approximately $270 million. Combined, these properties represent approximately $670 million in appraised value, sufficient to cover the $547 million in judgments, plus anticipated seizure and liquidation costs. Drop a comment right now if you saw this coming. I read every single one. Now, things get absolutely extraordinary. On the morning of January 21, 2026, federal marshals began executing the seizure orders simultaneously across all 3 locations. At the Westchester Golf Course, 6 deputy marshals arrived at 6:15 a.m. and presented seizure orders to the overnight security supervisor. The marshals were accompanied by a court-appointed receiver, 2 property appraisers, and a locksmith. Staff members arriving for morning shifts were informed that the property was now under federal control and that they should direct all questions to the receiver's office. By 7:30 a.m., the marshals had posted federal seizure notices on the clubhouse doors, changed all electronic lock codes, and established a perimeter to prevent unauthorized access. Golf course employees were told that operations would continue under new management, but that the Trump Organization no longer had any authority over the property. Members who arrived for early tea times were informed of the change in ownership and told that their memberships would be honored during the transition period while the receiver determined how to proceed with liquidation. At 40 Wall Street in Manhattan, deputy marshals arrived at 6:20 a.m. and presented seizure orders to building management. The situation there was more complex because the building houses dozens of commercial tenants who rent space from Trump's entity. The marshals and receiver spent the morning meeting with the largest tenants to explain that their leases remained valid and that rent payments should now be directed to the receiver rather than to Trump Organization accounts. By 9 a.m., federal seizure notices were posted in the lobby and building management systems were transferred to the receiver's control. The Doral Resort seizure in Florida began at 6:25 a.m. when 8 deputy marshals from the Southern District of Florida arrived with local police support. The resort was hosting approximately 400 overnight guests when the seizure occurred. The marshals and receiver met with resort management to coordinate a transition that would minimize disruption to guests while establishing federal control. By 8 a.m., seizure notices were posted throughout the property, and guests were informed that the resort would continue normal operations under new management. Staff were told that their employment would continue during the transition, but that they now reported to the receiver rather than to Trump Organization executives. That's when it became clear this isn't just another legal threat or negotiating pressure. The bombshell moment came when Trump himself responded via Truth Social at 8:47 a.m. Eastern Time, approximately 2.5 hours after the seizures began. His post, which was quickly amplified across social media and cable news, called the seizures an illegal attack orchestrated by corrupt judges working with the Biden administration to destroy him before the 2026 elections. Trump claimed that federal marshals had no authority to seize his properties, that the underlying judgments were fraudulent and would be overturned on appeal, and that the seizures represented the kind of authoritarian government overreach that Americans should fear. He specifically attacked Judges Kaplan, Engoron, and Cannon by name, calling them political operatives disguised as judges who were abusing their power to punish him for challenging the Washington establishment. The post ended with a vow that he would never surrender his properties and that patriotic Americans should rally to his defense against what he characterized as government tyranny. This response sent immediate shockwaves through legal and political circles. When a former president publicly declares that federal court orders are illegal and calls for resistance against federal law enforcement executing those orders, it signals one thing. He has decided that defying judicial authority completely is preferable to accepting the consequences of his refusal to comply with legal obligations. The claims that federal marshals acted without authority collapse when the seizure orders were signed by 3 separate federal judges based on Trump's documented pattern of evading payment of legitimate court judgments over a period of more than a year. This isn't the first time aggressive federal enforcement actions have been taken against high-profile defendants who refuse to satisfy judgments. Think back to 2013, when federal receivers seized multiple properties owned by R. Allen Stanford after his conviction for operating a massive Ponzi scheme. Stanford had attempted to shield assets through offshore transfers and complex corporate structures, but federal courts authorized marshals to seize everything from office buildings to personal residences to satisfy victim restitution orders. The Stanford asset seizures ultimately recovered over $500 million for defrauded investors. Then there was the 2008 seizure of Bernie Madoff's properties after his arrest for securities fraud. Federal marshals took control of his Manhattan penthouse, his Hamptons beach house, his Palm Beach estate, and even his yacht and personal jewelry to satisfy victim claims. The Madoff seizures demonstrated that regardless of wealth or status, federal courts will enforce judgments through asset liquidation when defendants refuse voluntary compliance. Subscribe immediately if you haven't yet. This content doesn't exist anywhere else. And let's not forget the numerous seizures of properties owned by organized crime figures under federal RICO statutes. When mob bosses attempted to shield assets through front companies and straw purchasers, federal prosecutors traced ownership through complex corporate structures and seized everything from restaurants to car dealerships to legitimate businesses purchased with illegal proceeds. Now, however, the Trump seizures are different. This is the first time federal marshals have seized multiple properties from a former president of the United States. The pattern is clear. When defendants refuse to satisfy legitimate court judgments and engage in asset shifting to evade collection, federal courts eventually authorize seizure regardless of who the defendant is or what political connections they maintain. The legal system cannot function if some defendants are permitted to ignore judgments based on their status or their ability to generate political support for their defiance. So what legal principles justified these seizures? According to federal civil procedure experts who reviewed the enforcement orders, the seizures are authorized under standard debt collection statutes that apply to all federal judgment creditors. When a judgment debtor fails to pay and fails to post adequate appeal bonds, judgment creditors can execute on the judgment by seizing assets, garnishing bank accounts, and liquidating property to satisfy the debt. Jennifer Taub, a law professor at Western New England University School of Law and expert in financial fraud enforcement, told Bloomberg Law that the Trump seizures follow exactly the same legal process that courts use in thousands of debt collection cases every year. She explained that Trump was given extraordinary patience and numerous opportunities to comply voluntarily, and that seizure is always the remedy of last resort when all other collection efforts have been exhausted. The fact that Trump is a former president entitled him to no special exemptions from the same legal process that applies to every American facing civil judgment enforcement. Here's the kicker. The enforcement orders include findings that Trump engaged in fraudulent conveyance by deliberately transferring assets to family members and shell entities to place those assets beyond the reach of creditors. Under federal law, such transfers can be voided, and the transferred assets can be clawed back and added to the pool of property available for seizure. This means that even assets Trump thought he had successfully shielded through transfers to his children or offshore entities may still be subject to seizure if the courts determine those transfers were made with intent to defraud creditors. Don't go anywhere. The most explosive part is coming next. And here's what should alarm everyone who cares about rule of law. This isn't just about Trump paying his debts or settling his legal disputes. If a former president can defy federal court orders for over a year, engage in deliberate asset shifting to evade judgment collection, and face no enforcement consequences, it signals that political status creates immunity from the legal obligations that bind every other American. Once that precedent is set, there's no turning back. Every future president would know that judicial authority ends where political power begins, and that court orders become optional for anyone who can generate enough public support to frame enforcement as persecution. This puts Trump's remaining business operations and his political campaign in an extraordinarily difficult position. On one side, they face the reality that 3 of Trump's most valuable and visible properties have been seized by federal authorities and will likely be liquidated within the next several months. That means Trump loses not just the properties themselves, but the ongoing revenue those properties generated through golf memberships, resort bookings, and office leases. Financial analysts estimate that the 3 seized properties generated approximately $75 million in annual revenue for the Trump Organization, creating a massive hole in the company's cash flow. On the other side, Trump must now explain to supporters and voters how he lost control of hundreds of millions in assets because he refused to follow the same legal procedures that every other American facing civil judgments must follow. The narrative of Trump as a successful businessman and master dealmaker becomes significantly harder to maintain when federal marshals are seizing his properties because he couldn't or wouldn't post appeal bonds that any competent business operator would have secured through standard lending arrangements. And here's the tricky part. There's no good path forward. Either Trump admits he lacks the financial resources to post the required bonds, which contradicts years of claims about his billionaire status and raises serious questions about the true value of his business empire. Or he admits he had the resources but chose not to comply as a political statement, which confirms that he deliberately defied court orders and makes the seizures entirely his fault. Neither option helps his political messaging or his business reputation. Legal and political analysts are calling this a self-inflicted catastrophe that was entirely avoidable. Bradley P. Moss, a national security attorney who has followed Trump's legal troubles closely, told CNN that Trump had multiple opportunities to post bonds, arrange payment plans, or negotiate settlements that would have avoided seizure entirely. Instead, he gambled that courts wouldn't actually enforce their orders against a former president, and he lost that gamble spectacularly. Norman Eisen, former White House ethics czar and senior fellow at the Brookings Institution, added that the seizures represent a watershed moment for accountability. He explained that Trump has operated for decades under the assumption that rules don't apply to him, that he can always delay or evade consequences through aggressive legal tactics and political pressure. The federal marshal seizures demonstrate that judicial authority ultimately prevails when defendants exhaust every accommodation and court patience finally runs out. Do me a favor and slam that like button because it genuinely helps this video reach more people. Even Chris Christie, former New Jersey governor and Trump critic, who nonetheless defended some of Trump's legal positions, stated that the seizures were appropriate under the circumstances. He told ABC News that when someone refuses to pay court judgments and engages in asset shifting to evade collection, seizure is exactly what should happen regardless of who that person is. Christie emphasized that equal justice under law means equal enforcement of court orders, and that Trump's political status should neither shield him from enforcement nor subject him to harsher treatment than any other judgment debtor would receive. So let's break down what this means. First, the immediate business impact is devastating. The Trump Organization just lost 3 major properties that represented both significant assets on its balance sheet and meaningful revenue generators in its operating model. The Westchester Golf Course, 40 Wall Street, and Doral Resort collectively represented approximately $670 million in asset value and $75 million in annual revenue. Losing those properties means the Trump Organization's asset base shrinks dramatically, its revenue declines significantly, and its borrowing capacity with lenders decreases because it has fewer unencumbered assets to pledge as collateral. Second, it creates catastrophic reputational damage that extends beyond Trump's immediate financial situation. Every potential business partner, lender, or investor now sees someone who had major properties seized by federal marshals because he refused to follow standard legal processes. That reputation follows Trump forever, making it vastly more difficult to secure financing, attract business partners, or negotiate favorable terms on any future deals. No sophisticated party wants to enter business relationships with someone who has demonstrated willingness to defy court orders and absorb property seizures rather than to comply with legal obligations. The seizures also raise profound questions about wealth, accountability, and equal treatment under law. Trump has claimed for years to be a billionaire with vast real estate holdings and business success. Yet when courts ordered him to post bonds totaling $547 million to appeal various civil judgments, he claimed inability to comply. If his wealth claims are accurate, posting those bonds should have been straightforward through normal lending arrangements using his extensive property holdings as collateral. His failure to do so suggests either that his wealth has been vastly overstated or that his properties are so heavily encumbered with existing debt that lenders won't accept them as collateral, both of which raise serious questions about the financial health of his business empire. This scenario has sent shockwaves through the real estate industry and the broader business community. Reports indicate that major commercial lenders and potential business partners are reassessing their relationships with Trump Organization entities after the seizures. Some banks are reportedly reviewing existing loan agreements to determine whether the seizures trigger default provisions or material adverse change clauses that would allow them to call loans or demand additional collateral. Meanwhile, Trump's political supporters are portraying the seizures as government overreach and political persecution designed to destroy him before he can return to power. Conservative media outlets are running extensive coverage, framing the Marshals' actions as authoritarian tactics reminiscent of dictatorships that confiscate opponents' property. Social media is filled with calls to protest the seizures and to support Trump financially to help him fight back against what supporters characterize as a corrupt judicial system weaponized against him. Things escalated dramatically when Republican members of Congress began calling for investigations into the federal judges who authorized the seizures. Several House Republicans issued statements demanding that the Judiciary Committee investigate whether Judges Kaplan, Engoron, and Cannon abused their authority by coordinating enforcement actions against a former president. The statements claim that the seizures represented political bias and selective prosecution designed to interfere with Trump's political activities. Stay with me. What comes next will completely change how you view the situation. Here's what makes this situation even more significant from a legal perspective. The seizure orders include specific findings that Trump engaged in fraudulent conveyance and deliberate asset shifting to evade creditors. Those findings create potential criminal exposure beyond the civil judgment enforcement. Federal prosecutors could potentially bring charges for bankruptcy fraud, wire fraud, or conspiracy to defraud creditors if they determine that Trump's asset transfers were executed with criminal intent rather than being merely aggressive civil litigation tactics. Legal experts have pointed out that there's a line between legitimate asset protection planning and criminal fraud, and that line is crossed when transfers are made with actual intent to place assets beyond the reach of existing creditors. The court findings that Trump engaged in systematic asset shifting to evade payment of existing judgments could provide the foundation for criminal charges if prosecutors decide to pursue that route. This goes far beyond one person's business empire or legal troubles. It's about whether the federal judicial system has the authority and the will to enforce its orders against politically powerful defendants who refuse to comply. If courts issue judgments and former presidents simply ignore them, counting on political support to shield them from enforcement, judicial authority becomes meaningless. Every future defendant would claim similar immunity, arguing that if Trump could defy court orders without consequence, they should be able to as well. If there are no consequences for Trump's pattern of defiance beyond the property seizures themselves, if he faces no additional sanctions or criminal charges for deliberate asset shifting, it signals that aggressive evasion tactics work and that the worst consequence is eventually losing some property through seizure. That's not a deterrent. That's an incentive to evade as long as possible, to shift as many assets as possible, and to comply only when absolutely forced to through martial action. The system cannot function if that becomes the model for how high-profile defendants respond to adverse court judgments. If this blows your mind, hit that like button right now. Here's the situation. Federal marshals have seized 3 Trump Organization properties worth approximately $670 million to satisfy $547 million in unpaid federal court judgments after Trump refused for over 14 months to pay the debts or post-appeal bonds. The seized properties include his Westchester golf course, his Wall Street office building, and his Doral resort in Florida. Court-appointed receivers are now in control of these properties and will begin liquidation proceedings to collect on the outstanding judgments. This is no longer theoretical or distant. Federal law enforcement has taken physical control of Trump's properties. Guests at Doral woke up to find federal seizure notices posted throughout the resort. Members at the Westchester golf course were turned away and told the property is under federal control. Tenants at 40 Wall Street are now paying rent to a court-appointed receiver instead of to the Trump Organization. When federal marshals show up at dawn with court orders and moving trucks to seize properties from a former president, we've entered territory that tests the very foundations of judicial authority and equal justice under law. If there are no additional consequences beyond the seizures themselves, it sets a dangerous precedent. Future defendants would know that the worst outcome is eventually losing property through martial action, making evasion and delay the rational strategy rather than prompt compliance with court orders. The system depends on defendants complying voluntarily or facing swift enforcement, not on courts exhausting years of patience before finally authorizing seizures. Keep a close eye on this story. The court-appointed receivers will begin property appraisals within the next week to determine market value and optimal liquidation strategies. Legal experts expect the properties will be sold through public auction or negotiated sales within the next 3 to 6 months. Trump's attorneys have indicated they will file emergency appeals seeking to block the liquidations, but federal judges have already ruled that Trump waived his right to delay enforcement by failing to post appeal bonds. And federal prosecutors are reportedly reviewing whether Trump's asset-shifting activities constitute criminal fraud that warrants additional charges beyond the civil judgment enforcement. Before we go any further, smash that subscribe button so you never miss content like this. Here's where things stand right now. Federal marshals have executed seizure orders on 3 major Trump Organization properties totaling approximately $670 million in value. Trump has called the seizures illegal and urged resistance, but the orders were authorized by 3 separate federal judges based on Trump's documented refusal to satisfy legitimate court judgments. Court-appointed receivers have taken control of the properties and will begin liquidation proceedings. This isn't just another legal controversy that will fade from headlines. This is a fundamental assertion of judicial authority against a former president who spent over a year defying court orders and engaging in asset shifting to evade payment of legitimate debts. What happens next could determine whether federal courts have meaningful enforcement power against politically powerful defendants, or whether judicial orders become optional for anyone who can generate sufficient political support to frame enforcement as persecution. The seizure orders are executed and irreversible unless overturned on appeal. The properties are under federal control. Court-appointed receivers are preparing liquidation plans. Now we wait to see whether Trump will finally comply with court orders by paying the remaining judgment amounts, or whether additional properties will be seized to satisfy the debts. The stakes have never been higher for Trump's business empire. The enforcement action has never been more complete, and the test of judicial authority has never been more direct. Pause for a second and hit that like button if you're finding value in this coverage. Hit that subscribe button right now because you won't want to miss any of the videos I release.